Vishnu Art Press, volume number 7, transcription number 1, explanation. Challenge in this appeal is to the order passed by the division bench of the Punjab and Haryana High Court. Division bench of the Punjab and Haryana High Court, ये capital आएंगे. Dismissing a writ petition small आएगा, filed by the appellant under article capital 2 to 6 of the Constitution of India, capital आएंगे. 1950 stop. Prayer in the writ petition was to quash QUASH the award dated 23/9/2004, under which the respondent number 1 was directed to be reinstated with continuity CONTINUITY of service with 50% back wages within stipulated time stop. The award was made by the presiding officer, दोनों capital आएंगे, Patiala PATIALA stop. The matter was before the labor court, capital आएंगे दोनों, on the basis of a complaint made by respondent number 1 stop para. The brief facts of the case are that respondent number 1 workman, MAN आएगा workman में, was appointed as bulldozer operator. पोस्ट का नाम है, कैपिटल आएंगे दोनों, बुलडोजर भी ऑपरेटर भी. बुलडोजर की स्पेलिंग है BULLDOZER, ऑपरेटर OPERATOR, दोनों कैपिटल हैं. विद द पेटिशनर मैनेजमेंट विद हाइफन और मैनेजमेंट आएगा कैपिटल on 1/11/1990 stop. Since his appointment was on 89 days basis, the same was extended from time to time till 5/7/1996 stop. Thereafter his services were not extended stop. The workman MAN raised an industrial dispute on the ground that his services were terminated by the management on 15/7/1996 without any notice. चार्जशीट विद हाइफन भी ठीक है, वन वर्ड भी ठीक है, अलग अलग भी ठीक है, तीनों ही ठीक होते हैं. इंक्वायरी ENQUIRY और कंपनसेशन एंड दैट द जूनियर्स टू हिम आर स्टिल इन सर्विस of the management and new persons were also appointed by the management after terminating his services stop. The government, capital आएगा, referred the dispute to the labor court, capital, for adjudication under section 10 within bracket 1 within bracket C small आएगा of the Industrial Disputes Act, तीनों capital 1947, and the labor court on 23/9/2004 made the award which was challenged before the High Court, capital आएगा, stop para. The stand of the petitioner management with hyphen आएंगे is that respondent number 1 workman was engaged, workman यहाँ small आएगा, capital नहीं करना, as bulldozer operator, capital आएंगे, on 89 days basis, and in that stop gap, one word भी ठीक है, hyphen के साथ भी ठीक है, arrangement he had worked from 1/11/1990 till 15/7/1996 but intermittently INTERMITTENTLY stop. He was never employed continuously, therefore did not work for 240 days in the preceding PRECEDING 12 calendar CALENDAR months stop. Thus denial of further extension EXTENSION of his service does not amount to retrenchment, therefore has been wrongly WRONGLY awarded reinstatement with back wages, one word ठीक है, stop. The labor court has not appreciated the fact that since the petitioner department, capital, is not an industry small आएगा, the services of respondent number 1 small आएगा were not governed by the aforestated, one word है, act, capital है, stop para. The labor court, capital, held that section 2 within bracket O small आएगा, of the act, capital, has no application to the facts of the case stop. In any event, the workman MAN had completed 240 days of work in several years stop. The appellants took the stand that respondent number 1 have not completed 240 days of work in any calendar CALENDAR year stop. He never worked continuously stop. The employer was not an industry stop. The labor court held that there was no compliance COMPLIANCE with the requirement of section 25F, F capital आएगा, हाइफन के साथ भी ठीक है और इकट्ठा लिखो तो भी ठीक है, of the act stop. The question whether department is an industry has to be decided against the management for want WANT of evidence stop. The onus ONUS was on the department to prove PROVE that the workman MAN worked only 180 days and not completed 240 days in the preceding 12 calendar DAR आएगा months from the date of alleged termination stop. Since no records were produced by the department, the claim has to be accepted in the writ petition या full stop है sorry accepted से पहले in the writ petition before the High Court capital. It was categorically CATEGORICALLY urged by the appellant that no appointment order was produced. Stop.